It is 10 a.m. on Wednesday, May 14th. And this is a public deliberation of the Baltimore County Board of Appeals in the matter of Megan Lee Brittain at 2821 Willow Avenue, or M&M's Childcare LLC, with regard to the application for a use permit pursuant to Baltimore County zoning regulations, section 424 and section 500.4, to operate a group child care center class A. And it is an appeal of a September 30th, 2024 opinion and order of the administrative law judge, wherein the application for the use was denied. Public hearing was held on April 10th, 2025 in person, at which Ms. Brittain was represented by counsel, and the protestant, Kiona Taylor, appeared pro se. Both the petitioner and her counsel filed memoranda in support of the proposed use, as did Ms. Taylor. A number of issues were raised that we should address, and I'll go through them and see if either of my colleagues has any additional issues. But there was also a lot of correspondence in support of the use, some of it lengthy, all of which we've had opportunity to read and digest. The issues were the standing of the protestant, the issuance by the county of the use permit on July 24th, 2024, without noting the request for a hearing, the applicability of a newly enacted section of the Maryland Annotated Code, the Land Use Article, section 4-216, the application and satisfaction of the requirements of section 424.4, both as to the character of the community and the impact on the community, the issue of equal protection raised by petitioner, the issue of setbacks from the fence between the properties, the applicability of residential transition area to a group child care center class A, and the relevance of certain factual matters that were raised before us, and the consideration of the impact of the child care center on adjoining properties as to noise, the appearance of the yard and maintenance thereof, the height and location of the fencing, and traffic safety of increasing traffic on this street. Those are the issues I identified. Mr. Stomack, do you have anything to add? Still can't hear you.
I said, I don't think my issues are any different than yours.
Mr. Paulshot?
I believe they're the same issues, yes.
And I would add generally the satisfaction of the 502.1 considerations that are required under section 424, somewhere under 424 A6 C. Okay. Let's start with standing of the protestant. I believe that the protestant is an occupant of the adjoining property and has standing to bring this appeal. What is your view?
I agree. I'm sorry. I agree. Go ahead, Bill. Sorry.
I agree also, Madam Chair.
And standing in these, we're an administrative body and we tend, I think under the Crown Development case, there's broad standing.
I mean, I think somebody can occupy more than one residence at a time. If that's the allegation, she has more than one residence. And then, sort of interestingly, I think beyond that, the standing to appeal from the ALJ to us is actually even broader because it's anyone who feels aggrieved can appeal. Although she's not the appellant here, the original petitioner is the appellant,
but she participated below.
Correct.
Which absolutely entitles her by the ALJ. The issuance of the use permit, I would say, was made incorrectly, and a permit issued by mistake is not a valid permit. And there's much case law to support that. And even though Ms. Brittain may have acted on having 12 children, it strikes me that the county screwed up, but it doesn't make it right, and that she does not have that right based on an invalidly issued permit.
I agree. And I mean, I don't fault her because she was getting a lot of contradictory information from the permitting office, it seems like. And they, in fact, said that they would stay any enforcement, even though they had withdrawn the permit. They weren't gonna fine her during the continuance of the proceedings, which I think is right, but also that could have been handled better from the get-go.
As to the applicability of section 4-216 of the land use article, as council recognized, that is not in effect until October. And until it's the law, it's not. And much as I recognize the argument for what it is, I don't think we can apply that to this case until it is the law.
I agree with that, and in that law in particular, it doesn't cover all the bases, safety, and those issues too. So even though that law will come in effect, it has to cover all issues of Baltimore County, and that's part of it. So I agree.
Mr. Stelmack?
I mean, I don't think we can consider a statute that hasn't gone into effect yet.
The character, I'm gonna move past the character of the community till we get to 502.1. There was an argument on equal protection. I don't see that there was a lack of equal protection. There is a process which is followed and was followed in the case of each group child care center that was cited. Everybody was subjected to the same process. And where there is, and this is a process that applies not just in the case of child care center, it appears elsewhere in our zoning regulations. And to the extent that everyone is treated with the same rules, I don't see where there was a lack of equal protection.
I don't think there's enough of a factual record for us to make any kind of determination about whether someone was denied equal protection. I think that there is essentially just a bare claim that people are being treated differently. But the only thing in the record that pertains to that is, I think there was a chart submitted that talks about how many licensed large family child care homes there are in Baltimore County, but there's not enough information here because a licensed large family child care home is different than what we are talking about, which is a group child care center, Class A, which even though those are similar, they are different for state and local purposes. And we just don't have enough information here. And I honestly don't really understand the argument anyway. So
I agree with that also. We all go by the laws and codes. But each case we come across, in every case, they're not all the same.
Okay. The applicability of the RTA to group child care centers Class A, I think the law is pretty explicit that under Section 424.4A6D, the zoning commissioner can modify it, but it does apply. So I think that argument is just incorrect. I think that petitioner's counsel maintains that the RTA does not apply. And it's pretty clear to me under the law it does apply, though there is discretion in the ALJ to modify it. Does not apply to 8, does apply to 12 children. Once the category of child care goes from family to Class A.
I'm going to be honest. I took this in a different direction just because I don't think it's in a RTA. And so I don't think the provisions concerning an RTA are applicable. I think they're trying to use language in that section to essentially say that the zoning commissioner has a kind of discretion to ignore some of the rules that they don't, but I may be reading that differently than you.
I think it applies unless it is explicitly modified.
I agree with Chairman Tompkins.
I guess my question is, what is the effect of the RTA then?
Oh, it imposes buffers, setbacks. I mean, an RTA protects unlike uses that adjoin one another, where one abuts a DR zone. And many different uses generate an RTA. So if the RTA were not modified, there would be a buffer requirement. There would be setback requirements that are different. And they don't apply to a family child care home, but they do apply otherwise. And then all the other issues to me are really go to the 502.1 standards regarding the impact on the community. And just to go through them briefly, you know, we're talking about the noise, the clutter, the traffic, the fencing, traffic safety, not the setbacks so much, but the 502.1 are talking about being detrimental to the health, safety, or general welfare of the locality, whether they tend to create, the use tends to create congestion in roads, streets, or alleys, creates a potential hazard from fire, panic, or other danger, that overcrowds the land and causes undue concentration of population, whether it interferes with the adequate provision for schools, parks, water, sewage, transportation, or other public requirements, conveniences, or improvements, or interferes with adequate light or air, or if it's inconsistent with the purposes of the property zoning classification, or in any other way inconsistent with the spirit and intent of the zoning regulations, whether it is inconsistent with the impermeable surface and vegetative retention provisions of the zoning regs, or is detrimental to the environmental and natural resources of the site and vicinity, including forest, streams, wetlands, aquifers, and floodplains, and for consideration of solar facility use. So what do you think, Mr. Paulshek?
Well, with this class, because of the narrow streets, the bus, and with the you know, both porches are not. It's an unusual piece of property to a degree. They're both side by side with porches facing each other on side. There's no change in your structure of the building itself. And there was a child hit by a bus, whatever the reason, but in that vicinity. And
So we're looking
so-
at traffic safety. Mr.
Correct.
Stelmack?
I'm still kind of hung up on the RTA thing, to be honest.
We can come back to that if we can talk about
Okay.
the other things, and we'll come back to that.
Well, why don't you go first while I get my thoughts together then?
Sure. I think traffic safety is a big issue. You're talking about a narrow street without sidewalks by the property. There's no real dedicated area for unloading and loading children, even though there is a driveway. You're talking about cars backing in and out at the same time of day. And my concern here is that traffic safety is not something that is easily dealt with without a dedicated drop-off and pickup area. Parking on the street creates a problem for school buses. I just think that the traffic safety would render this location less desirable than another location in the same zone, something that, say, has a circular driveway, or could a wider street with curb and sidewalk. I just don't see where you increase the number of children that you don't compromise traffic safety. And because there has been one incident and because there was testimony about parking on the street interfering with buses turning onto the street, that's a big concern for me. I also think that the lot is small and you are doing some overcrowding, though not significant. I think that the other factors are not significant enough to render this a worse location than other locations in the zone. I think the traffic safety is. And we can come back to RTA, and I also want to talk about setbacks from the fencing. But Mr. Stelmack, how are your thoughts? Are they together?
Yes, I mean, I agree with you that the traffic safety is an issue, but I don't I don't think that there was enough factual testimony that was non-hearsay um that I feel comfortable counting on to make a decision um as far as making that actual determination. I mean, I'm with you that I think there is a legitimate traffic issue there. And I think adding more students will exacerbate that issue. But I don't think that there was enough testimony presented to sustain a finding on it.
I, this is not only classified as the large group daycare, but it's a livable home, as we see.
I'm having trouble understanding you.
I'm sorry. Just to help to clarify that it is a traffic issue. There is photos of, it's livable. A trailer is parked in that 6-spot camping trailer for whatever amount of time. The business will go around year round. And that only congests even more issue with safety because now it's a livable home with combining. So I think the safety issue is going to be, rather it's only for a month, a week, it's a safety issue, and traffic is going to be a problem. So,
Okay,
sorry.
I think we agree on that, Mr. Polshak.
Okay.
Okay, let's talk about RTA. What are your thoughts, Mike? I don't know if you've.
Okay, so I just kind of want to back away from that because again, I think it's probable that I do not have a good understanding of the concept of an RTA right this second. Okay. But just going through the requirements of 424 generally, as they are applied to the group child care centers, I mean, the code distinguishes, all right, I'll back up even further. The code distinguishes between what it calls a group child care center and a group child care center class A. And it seems to me that the meaning of the class A is meant to be essentially an accessory use on a residential house. And the group child care center is meant to be like a facility or
Principal use.
a principal use. Now, there are parts of the code that really don't distinguish those two things. And I think that the ALJ kind of assumes that the Class A use is a subset of the overall group child care center. Now, I don't know if that's the correct interpretation or not, but so for instance, in 4241, when we talk about the fences, it says, with respect to group child care centers, well, all right, let's back up even further. When 4241 general starts with family child care homes, group child care centers, and nursery schools shall meet the following requirements. It does not distinguish there between group child care center and a Class A, which I think leads me to believe that Class A is just a subset of a group child care center. And B says, with respect to group child care centers and nursery schools, outdoor play space abutting residential property shall be fenced. Fences shall be solid wood stockade or panel, a minimum height of 5 feet, and no closer to the property line than 20 feet. If you go down to 4244, it talks about group child care centers as an accessory use. It says group child care centers Class A are permitted as accessory use with a single family detached dwelling in all residential zones. It lays out what you need to get the permit. 4245 talks about group child care centers as a principal use, and it says here's what you need to meet if you're going to have it as a principal use. 424.7 talks about the bulk standards for group centers in DR zones. And this is kind of what I'm hung up on, is because the ALJ, in her opinion, says that there is no exception here for the Class A use. And so I'm inclined to agree with her that the code says that if you want to be a group child care center in a DR zone, you have to have at least a 1 acre lot. You have to have these minimum setback requirements. You have to have the fencing as per point 1. Now, I think what you're saying with respect to the RTA, and I do not understand this from the briefs, is that for some reason, the zoning commissioner is or may be allowed to disregard some of those requirements. But I don't read it to say that. So this is where I'm not following you.
Well, RTA is provided under 1B01.1, under a whole different section of the code.
Right.
And it would impose additional buffering requirements.
Okay.
In addition, and it measures differently from improved and unimproved DR property. It's just one more layer of regulation.
Okay.
It was not imposed. When it was imposed, it was because people were putting residential zones next to business zones and apartment zones, and it affected the single family residential areas. I mean, you're going back to 1970. It's an old and perhaps anachronistic provision, but it remains. And I think the way the council dealt with it with child care centers, which was a later enactment, was to put the discretion in the zoning commissioner, because these group child care centers have substantial protective requirements built in. I think this law tries to balance the safety of children with the impact on neighbors. In my days practicing, child care centers often encountered opposition from primarily adjoining neighbors, no matter the quality of the provider. And there's no question that Ms. Brittain is a highly regarded provider, both among her colleagues and among her customers. And I don't think this is any reflection on the services she provided or the care she provides. I do think the property cannot meet the criteria without substantial variance relief. And from my personal point of view, I think the thing that does it for me is more the traffic safety issue than the size of the property itself. That 20-foot setback, as I read the law for the fencing, is only from an abutting residence. There's only one abutting residence. But it doesn't change the fact it's not met. So my inclination would be to affirm the ALJ, but on slightly different criteria.
Well, again, I still don't, with respect to 4.424.7, I agree with the ALJ that the property doesn't meet the bulk standards. And going back to the statute that we were talking about, I think the effect of the statute is essentially makes the county allow Miss Brittain and other providers to have up to 12 children and not have to meet these standards. It would be as if she had to meet the same standards as the family child care home, which she already does by right. So, and I mean, honestly, I think that's fine. It's good. But I think as of now, she is applying for a group child care center class A. And I get that she's doing that because the state told her she has to. But I don't think she meets these criteria. And I don't
either.
I mean, it's pretty clear. I still,
what's before us is not an application for variances or to modify it. We're really limited to the statute because they're not asking for other relief. So I'm entirely on board with you, Mr. Stelmack.
well, let me ask you as a matter of speculation, if she applied for variance relief from some of these requirements, I mean, is she entitled to make that application?
She is entitled to make that application.
But as a matter of practicality, it probably makes more sense just to wait until October when the law changes.
I can't answer that.
Well, I'm just talking out loud.
Saying we can't determine that till the law takes effect.
Right.
And she is certainly aware of the law and has made us aware of the law and is represented by able counsel. The timing just isn't very good for her. So are we in agreement to affirm based on 424.7 and really the safety issues?
Well, I think, I don't know if that's as a de novo matter. Do we say, I don't know if we affirm however.
We can.
Okay.
We have to justify our decision based on the testimony and evidence before us. But we would still be denying the application.
I mean, I concur with the denial of the application. I would probably briefly dissent from the issue of the general welfare for the reasons I said already. Can I say one more thing real quick?
You
I
can say whatever you want.
like like you, I was very impressed with the letters of support from the community, and our decision in no way reflects on Miss Brittain's operation and the childcare that she provides. And I do want to say that I was particularly impressed with one letter from Kathleen Sipes from Notre Dame. That is because Mrs. Sipes was my elementary school principal when I was at Our Lady of Mount Carmel Elementary from 1985 until 1990, whatever. And I hope someone will please give her my regards.
I recognize that Ms. Brittain is a good provider. I recognize how important having childcare available is for working families. I recognize that my life would have been very different if it had not been available when I had a young child. I recognize there is a huge need, and to the extent that the property is what it is and the law is what it is, I think at this point in time, our hands are tied, as you've described. And I think Ms. Taylor did an able job making her case. I have to say, I'm always disheartened by disputes between neighbors that should be able to find a way to resolve things, and it makes for difficult cases. And probably why we've taken as much time as we have to deliberate it.
Absolutely. And I'm absolutely sympathetic with Miss Taylor as well. I can understand why having a child care center next door might not be the most ideal situation.
Which is why the law imposes fencing and setbacks, and but children are part of our world, and we try to balance their needs against the neighborhood. So it makes for tough decisions. Mr. Polshak, do you want to add anything?
Well, two great people living next to each other. To see the entrepreneurship of a small business woman and two friends. And I say friends because what we heard throughout the case. And county codes and laws are tough, but it was an honor to be with those two and listen to both of them, for sure.
All right, so let me conclude by saying we will deny the application based on the inability of the property to satisfy the bulk regulations, with the added concern by a majority of the board as to the traffic safety issues that could affect child safety, which is the primary bottom line concern for me. Is that acceptable?
For me, yes, thank you.
Yes.
Okay. Having said that, I'm going off the record and concluding the public portion of this deliberation. We'll figure out the administrative issues. We will issue a written order and get it to everyone as promptly as possible. Thank you, everyone.
Thank you.